A lot of people think about estate planning as being planning that needs to be done for end of life. And it is true. Your estate planning documents will have the necessary documents to plan for end of life estate administration. But estate planning is far more than just planning for end of life. And we encourage people to plan earlier on in life. The reason for that, well, there's multiple reasons, but let's just talk about you and how to protect yourself. Let's say you are in your 30s or in your 40s and not thinking about end of life at all. So you're probably thinking, oh, I don't need an estate plan. Well, I would encourage you to get an estate plan, and this is why. Estate planning documents are not just for end of life. They are for protecting you while you are alive against the what ifs. By that I mean, what if you're in an accident? What if you are in the hospital? What if you are temporarily or even permanently incapacitated so you can't make your own decisions? If you don't have the necessary, what I call living documents, the documents that protect you during the span of your lifetime, then if something happens to you such that you can't make your own decisions, the court steps in. The court takes over. The state takes over your affairs. We want you to protect against that through your durable powers of attorney. Durable powers of attorney grant authority to somebody else to make decisions on your behalf if you can't make your own decisions. So you'd likely have a durable power of attorney for financial matters and a durable power of attorney for personal or medical decision making. That can be the same person, the same document, or you can separate them out. In elder law, we typically separate out those two documents because sometimes you want different people to make decisions for you for your health versus your finances. And also because as elder law attorneys, we know that there is, it's very important to include in your financial powers of attorney certain authorities to help get government benefits if need be. If you're incapacitated, so you can't make your own decisions, there is an increased likelihood that you will need government benefits. So living documents make sure that you put into place and have the legal documents required so that the state doesn't step in and doesn't try to manage your affairs. Instead, who does would be the person that you trust or the persons you trust to make decisions for you if you're not able to do so. When it comes to end of life, we all know that at end of life you're going to need a will, or you're going to need a trust, or you're going to need something like that to say where your assets go. There's also this document that's called a living will. It is not a will. It doesn't say where things go on your death. A living will is also called an advance directive or a healthcare directive. And that document, of course, comes into effect at your end of life. And it will say, what do you want in terms of medical treatment? Do you want heroic measures? Do you want to be fed artificial, nutrition? Do you want breathing assistance? Not just for, the acute treatment. Most people want whatever medical treatment they can get because it's for the acute condition, and if they get that treatment, they're going to be better and back to living life. Really what we're talking about when we're talking about these advanced directives, end of life directions, are all that's been done. You are now at end of life where you the doctors say that you are in a terminal or permanent vegetative condition, and whatever treatment they give you isn't going to make you any better. It'll keep you going, your body going. It'll prolong the dying process. So we do recommend that you give some thought to what would you want if you're in that condition. I can tell you after meeting with many clients that the majority of people say that if they're in a vegetative condition and if the medical treatment is just there to prolong the dying process, that they would be allowed to pass peacefully and in comfort. But their decision and what most people want that might not be what you want. So especially important is that you put down your wishes in writing, meet with your elder law attorney, make sure you understand a little bit more about that process. And once you have your documents in place, please share that information, the information with your healthcare agent, the person you've appointed under your healthcare power of attorney. What are your wishes if you were to be in a permanent unconscious condition? Let them know what you would want. Have that discussion. I know it's not necessarily a fun discussion, but it's a really important one to have.